Hi, my name is Megan Hunter. I am an attorney with Hunter & Hunter LLC, a firm that I founded to increase access to justice for environmental matters here in Ohio. I'm out of Akron, Ohio. And I'm here today representing Freshwater Accountability Project, a client of mine who they're a grassroots nonprofit organization, and they've been working very hard on issues related to hydraulic fracturing for at least since 2010 here in Ohio. And they have members throughout the state of Ohio, as well as some members in Pennsylvania. And Freshwater Accountability Project's main mission is really just to be a community advocate. So to be a central contact for people impacted by industry. But also they really identify as an organization that collects information, so does all the public records requests that individuals might not know how to do, pursues access to that information, acquires that information, and then makes it publicly available to help people empower themselves to play a bigger role or any role in the environmental decision-making that is directly impacting them. So I submitted an amicus brief on behalf of Freshwater, and that is what I will be referencing today and walking you through today. So I'm not going to go through just a summary of every human right that I argue has been violated here in Ohio from the hydraulic fracturing industry. Instead, I'm just going to jump right into the meat of it. So first, I think it's important in terms of semantics, and you're seeing me glance to the side because I have some notes just here beside me. In terms of semantics, I think it's important to note that while the industry might call hydraulic fracturing, it might try to limit that term to mean just the reaching of natural gas resources that weren't otherwise available through conventional methods. Really what we're talking about, or when communities are impacted by hydraulic fracturing, really what they're talking about is the larger issue of what they sometimes refer to as an occupation or an invasion by the unconventional oil and gas industry. And that comes in the form of mass volumes of truck traffic, of pipelines, of all sorts of infrastructure, compressor stations, numerous well pads, each spanning multiple acres. So we're not just talking about a specific technique of extracting oil and gas. We're talking about an industry that transforms rural communities into an industrial landscape, often without them thoroughly understanding or participating in what is taking place. So that's, I think, just an important clarification to make in terms of when I say fracking, what I mean, or what my client or the individuals I mentioned the testimony about, what they mean. So first and foremost, I'll just walk through a list of the rights that we found have been violated. So in terms of substantive rights, the right to life, security of person, and bodily integrity. So the Universal Declaration of Human Rights states plainly, everyone has the right to life, liberty, and security of person. Well, here in Southeast Ohio's gas patch, that's not taking place. So I submitted with my amicus brief testimony from numerous individuals, just including the testimony of Carrie Bond, who lives down in Noble County, Ohio, right in the middle of the gas patch. She owns over 200 acres and has a pad on her property and a compressor station very near to her home as well. Carrie Bond describes being terrified to go to sleep at night for fear that she'll be blown up in her sleep. And that's due to literally being awakened during the night by the massive blowdowns that take place at the compressor station. So that's a term of art in terms of what's happening, but I'm sure you've heard so much of the factual basis of this now that I won't go into detail about every procedure here, but they're awakened by the compressor station nearby their home and literally fear for their lives. And that's not an uncommon occurrence here in Southeast Ohio. Indeed, you see the media reporting on that regularly. In June 2014, the Eisenbarth well pad explosion resulted in people fearing for their lives, a 1 mile evacuation notice. February 2018, again, a 1 mile evacuation notice after another well pad explosion. So these types of regular occurrences, particularly from compressor stations, but also from well pads, truly do leave local communities fearing for their lives and not feeling at all secure in their person, and realistically under threat. There's also, I wanted to speak about the right to help. So again, the UN Declaration on Human Rights states everyone has the right to a standard of living adequate for the health and well-being of himself and his family. So in addition to these explosions and actual threats to in an emergency sense, there's also the just daily health impacts. And I submitted testimony again from Carrie Bond, as well as from Jill Hunkler, and numerous other individuals who live near compressor stations. And I can also testify on my own behalf that this is a type of infrastructure that I have most frequently people coming to my office about the harms from compressor stations, the air emissions and the health impacts that they experience as a result of those air emissions. People describe, so Ms. Bond and Ms. Hunkler describe vomiting, headaches, dizziness, vertigo, eye, nose, and throat irritation, rashes, numbness in the body, aches and pains, a just general sense of not being well. So in addition to the health impacts from compressor stations, from other types of infrastructure like the well pads, you hear testimony. Ron Gullah testified that the well pad emissions from the well pad have caused him to have a fissure below his nose and joint pain. In addition to that, here in Ohio, we use the waste for all kinds of things. Waste from hydraulic fracturing operations, so brine that flows back from the operations, is spread on roads as a de-icer and dust suppressant. When that brine dries and becomes windborne, people describe eye irritation, difficulty breathing, again, nausea, dizziness. And some people who have been diagnosed with different forms of cancer have certainly raised concerns that is related to that exposure. And again, detailed testimony I submitted with my brief, but here I'm just summarizing to you. The right to a healthy, viable, and supportive environment, Principle 1 of the 1972 Declaration, adequate conditions of life in an environment that permits a life of dignity and well-being. So Pennsylvania, not Ohio, where I'm located, but Pennsylvania, interestingly enough, has enshrined a similar value in its constitution. Article 27 states that people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Testimony from Carrie Bond, as well as Marianne Stein, that I submitted with my brief, details how in many of these landscapes that are near unconventional oil and gas infrastructure, be it a compressor station or wells, there's literally a loss of ecological vibrancy or life in these communities. People describe that the birds that they had always seen every year no longer return, that their farm animals have tumors, farm animals gazing into the distance before dying, just a lot of general decrease in life and ecological well-being near these sites of oil and gas development. The right to property. This one I'll spend a little more time on, just because I've, as an attorney here in Ohio, worked a fair bit on it. So again, the Universal Declaration states everyone has the right to own property. No one shall be arbitrarily deprived of his property. Ohio's Constitution states private property shall ever be held inviolate, but subservient to the public welfare. And the 5th and 4th Amendments of the US Constitution respectively state, no person shall be deprived of property without due process of law, nor shall private property be taken for public use without just compensation. And no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of property without due process of law. Well, here in Ohio, that happens regularly in terms of the deprivation of property without due process of law, and the taking of private private property for private gain by the state. Ohio is different than many other states in the US in that it has a unitization law, which is different than a forced pooling law. So it's very common, you see these laws and they've been upheld by courts again and again, to have certain pooling requirements where you can be forced into giving over your mineral rights just to meet spacing requirements to allow for the efficient production of oil and gas. And that's to avoid this problem kind of like commonly thought of with conventional drilling of you just don't want to stick too many straws in one bucket kind of thing. Unitization in Ohio is quite different than that. So unitization in Ohio, you have a situation where if an operator can demonstrate that they own 65% of a unit that they would like to develop. So they can just draw a line of what a unit that they would like to develop is. These units can be as large as 1,000 acres. If they own 65% or have access to 65%, control over 65% of the mineral rights associated with that unit, and they can demonstrate that it is more profitable than not for them to develop the remaining portion of the unit, so the remaining 35%, then they can go to Ohio's Department of Natural Resources, which is who regulates oil and gas development in the state of Ohio, for an order to take those mineral resources from unleased mineral owners. So, you know, people are often shocked to hear that number of 65%. In terms of how these hearings go, unleased mineral owners are notified that a hearing will take place. They are able to attend the hearing. They often do not, but they are able to attend the hearing, but the hearings tend to go verbatim, where oftentimes the attorneys for the Ohio Department of Natural Resources are almost indistinguishable from the attorneys by the operator applying for the order to unitize. So individuals are often left confused if they themselves are not represented by an attorney. They're often left confused about who is representing them in such a procedure, who they can trust in such a procedure, and who is representing the public at large in such a procedure. So after that hearing takes place in terms of the process for unitization, orders have always been granted in favor of the company consistently 100% of the time in the state of Ohio. Those orders have also been identical with the exception of a couple phrases. They did start clarifying the term gross proceeds recently and net proceeds in their more recent orders, but until that time they were all verbatim. Individuals do have a right to appeal that order taking their property. They have a right to appeal that through another hearing that is also done by the Oil and Gas Commission, which is another part of the Ohio Department of Natural Resources. Again, they don't have to have an attorney to do this, but without an attorney, it would be quite difficult to do so. And to be clear, when they appeal that order, they're going up against their government. They're not going up against the operator. So they're appealing the government's decision to take their property to give to a private company. I submitted testimony by Patrick Hunkler, who outlines his story with unitization, how he felt throughout the process as someone who had relocated and spent his life working hard to relocate to Southeast Ohio, where he, quote, poured his blood, sweat, and tears into building a country retreat for his family that reflects his values, using recycled materials, conserving water, running solely on renewable energy, and active and passive solar. So he had found the perfect homestead for him and his family, and he had held out and refused to lease despite endless pressure, constant pressure from landmen to lease his property. He had held out, as well as pressure from his neighbors to lease the property so they could move forward with the unit and the neighbors could get royalty payments. He continued to hold out, only to have his government take his property from him to then be handed to the oil and gas company. And we hold that's a violation of the right to property, both under international standards and international law, but also under US constitutional law and the Ohio Constitution. In terms of challenging that all the way up through an appeals process in the Ohio courts, it just simply hasn't yet. Nobody's been able to fight the battle. It takes a lot of financial resources, and when you're up against a large company like these operators, it becomes next to impossible for a landowner to wage such a battle in the courts. In addition to the unitization problem with regard to the taking of private property in violation of human rights standards and US law, we also see the eminent domain taking of property for pipelines. And I want to be clear that this is not exclusively for natural gas pipelines, but an important part of the natural gas industry is also the plastics industry, so natural gas liquids, and the transport of ethane from natural gas liquids to ethane crackers. So then the natural gas liquids can be used in plastics production. Kinder Morgan, an operator that was building such a pipeline for the purpose of producing plastics in Canada, it filed 130 eminent domain cases to take private property for the purpose of transporting natural gas liquids to be made into plastics by one company in Canada. So again, the taking of public property for private use, for clearly private use. I'll move on from the taking of private property. And again, I'm going to quickly go over some of these because I feel like I can't speak to them as well. But they definitely are the case here. So the right to respect for private and family life. Testimony I submitted with my amicus brief detail how landmen repeatedly pit families against one another to secure leases. And this results in immense turmoil. And it can be immediate families. It can also be extended families. But it's a strategy that is certainly used, and it's used deliberately. This would be in violation of Article 12 of the Universal Declaration of Human Rights. The right to peaceful assembly and association. People who have been impacted by oil and gas industry, I submitted testimony by Ray Kimball, Jill Hunkler, Leatra Harper, and Carrie Bond, have all had statements made to them saying that their lives are at risk because of their outspoken behavior against the impacts they are suffering under oil and gas. So that is certainly a human right that is threatened in this current environment here in Ohio. Procedural rights. And again, as an attorney practicing in Ohio, I can speak more here to my experience as well in witnessing this taking place regularly. So some of the things that the Our House Convention establishes is that the public has a right to easy access to a wide array of environmental information, to be informed of all projects impacting their environment, and an opportunity to participate during the decision-making and legislative process, and judicial or administrative remedies if the state fails to adhere to environmental law or the rights to information and participation in decision-making. So Freshwater Accountability Project, who I'm representing here today, regularly uses public records requests to access information, and citizens who know to do so often will do so as well. But one thing that they run up against here in Ohio is that they have no legal right to ask for particular information. They may only ask for specific, readily identifiable documents. So people are often in the situation where they know the information they're trying to get, and they can't figure out the words to, with reasonable clarity, identify a specific document that would contain that information. And so then the agency under Ohio law is required to work with the individual to help them identify such documents, but that can look as simply as, here's a list of the way we keep records, or very vague assistance. It also can be abused by the agency if the agency does not want to be forthcoming with information. The requester has no way of verifying how helpful an agency is or is not being. And this is a huge hurdle for those trying to educate themselves on what's happening in their communities. There's also just simply no centralized area where you can find out what's going on in your community. You can't go online and log into Ohio Department of Natural Resources website and suddenly figure out the pipeline going in down the street from you, who's putting that in and what type of pipeline it is. It's extremely difficult to get that information, and it takes you oftentimes going to the Ohio Department of Natural Resources only to be pushed over to the Ohio EPA or Ohio Department of Transportation. And citizens are often trapped in this position of staying on the phone for hours, going from agency to agency without anyone being able to provide an answer. This is supported by previous testimony presented by Attorney Rick Solly in Ohio at the Ohio Citizens Tribunal. And it also demonstrates how, and Rick spoke to, and I can also speak to, that those documents that are not appealable or do not have direct implication for legal recourse are often not made available on Ohio Department of Natural Resources website, whereas those that you can't do anything with legally will be. And so that's just another hurdle of ways that it's difficult for individuals to find out when a permit is being issued, to find out how to challenge that permit. And then in terms of access to justice and the right to equality and non-discrimination in environmental matters, you have a whole nother issue. So even if you are able to access the information, in order to access justice, typically you need an attorney. And quite frankly, most of the people who are impacted by this industry simply do not have the funds sitting around to secure one. And that leaves them without legal recourse. And nonprofit groups can do their best, but they are limited in what they can provide, just in terms of they themselves are stretched thin, which leaves poorer individuals unable to access justice, whereas wealthier individuals may have a chance to be able to. Indeed, those cases that we have seen be fought in the Ohio legal system are by wealthier individuals. Even individuals who are able to retain counsel. So I give the example here of a firm that I previously worked for, Fair Shake Environmental Legal Services, opened its doors in Ohio with the intention of providing legal services on environmental matters to modest means clients. And they've done an excellent job of representing individuals who otherwise would not have access to representation. And I've followed in those footsteps with my own firm. Even when that is taking place, people who are able to receive representation through people like myself or Fair Shake Environmental Legal Services run up against the problem of experts. So you're up against oil and gas companies who have a seemingly endless budget to refute your case, and you're there with so few resources to provide an expert. So we're talking about someone who is facing problems in their home from a compressor station, for example, to get just the noise study to find out what the levels of noise are that are causing people to lose sleep, that are causing heart palpitations. A study like that can be as much as $30,000. These are folks who don't make $30,000 in a year. How are they ever supposed to be able to pay for something like that? And the same can be true for people suffering from health effects, from other health effects other than those brought about by noise. Getting the air canisters out there to do the testing is expensive. One would think that the government, so that ODNR, Ohio Department of Natural Resources, or Ohio Environmental Protection Agency could step in and provide those resources. But what we find is Ohio Department of Natural Resources has sole authority over oil and gas in Ohio. So they often, first of all, they're under-resourced, so they don't step in. Secondly, they have a bias towards the oil and gas industry, so they do not step in. And that results in, you can't use the government agencies to then collect the data for you that would be helpful in legal recourse. So citizens are really left without the ability to access justice when they are harmed by this industry, which is a violation of numerous standards of procedural human rights. So I'm not sure how I'm doing on time. So if there are any questions, I want to be clear, feel free to interrupt me or to follow up. But in terms of how to respond to what is happening with oil and gas development in Ohio, it is warranted that states and non-state actors be held responsible and liable for the violations to human rights that are taking place. So in the guiding principles on business and human rights, it states that states should enforce laws that are aimed at or have the effect of requiring business enterprises to respect human rights, and periodically to assess the adequacy of such laws and address any gaps. That they ensure that other laws and policies governing the creation and ongoing operation of business enterprises, such as corporate law, do not constrain but enable business respect for human rights, and that they provide effective guidance to business enterprises on how to respect human rights throughout their operations, as well as encourage and where appropriate require business enterprises to communicate how they address their human rights impacts. Here in Ohio, the state is doing the opposite. It's predominantly looking the other way. When government receives, when ODNR, when Ohio EPA receives complaint after complaint, they either do not have the resources or the will to respond frequently.
This probably is a good time to start tying it up a little bit, Megan.
Okay, great.
But we want to have time for questions from judges too. So.
Okay, so I would just say that I recommend, and Freshwater Accountability Project recommends a moratorium on all unconventional oil and gas development, and a holding that Ohio, Pennsylvania, and the U.S. governments are responsible and liable for the violation of human rights recognized and protected under international law, as well as damages issued to the impacted public. So I'm happy to answer any questions.
Gil Beringer, I've got a couple of questions. Just a simple one because I missed it. What is the name of that legislation? The one where they can, with the 65%, they can take your.
It's a statute in Ohio. We refer to it as the forced unitization statute, but it's 1509.28, ORC 1509.28.
Similar statutes are operative in other states, is that right?
That's correct. I am of the opinion that Ohio's is distinguishable from those statutes in other states just because of that 65% number is lower than you have in other states. And also the units here are larger, so there's no cap on units. So you don't see units that are that big in Pennsylvania, for example. You wouldn't see 1,000-acre units.
And it was a surprise to me. It almost sounded like you said that those units could be sort of gerrymandered in a way. They could sort of be picked and to help industry.
Right, and indeed they are. But I mean the unit, it has to reflect truly what they are intending to develop, and there has to be a unit plan for development that clearly lays out, where the wells will be and where the laterals will be. So all of that will have been submitted, and indeed often well pads they can be constructed and are constructed prior to such a unitization order being granted. So you could have your permit for construction granted. You could go ahead and construct that permit, even though you need that unitization order to be able to develop that well. And I think that just speaks to how much of a rubber stamp and a done deal this already is.
A couple of other points. So what you're saying is that in a sense, I mean, to conceptualize it, this is a kind of private eminent domain, but it's not but eminent domain is another one that they use, and they've bastardized that by taking property for private corporations for private use and profit.
Right,
So
and
two systems that they use, both look kind of like eminent domain, but they're not, and they're unconstitutional. And I'm wondering. Well, let's say I'm surprised that hasn't been challenged. I mean, it seems fairly clearly unconstitutional, although that doesn't mean the courts would call it such.
right. Well, I think several things are happening there. I think that, the definition of what constitutes a public use has been creeping in your U.S. law. So that's one issue. But here, I do think it's distinguishable in terms of this clearly being for private use. In terms of why it hasn't been seen in the courts, it's because of this appeal process, is my understanding, is that if you have that first hurdle of an administrative appeal process before you can even access the state court, people often settle at that administrative level, and so then it never gets to the next level.
Yeah, and from what I understand, from what you say, my understanding is then that really what we call in Australia and other places just legal aid, where there's significant funding for community law centers. This isn't really happening in the States.
Well, we absolutely have.
Sorry, I was just wondering, or if it does, has austerity ventured onto the scene and the funding dried up?
So there's definitely a strong legal aid system here in the U.S. in terms of how austerity has impacted that funding. I cannot speak to that. I know it certainly has impacted that in the criminal sector in terms of public defenders. It's hurt their funding. What we find with environmental law and representing individuals on these types of matters is legal aid simply doesn't have the expertise or the time. If I'm working some of these environmental cases, it's all my time is gone to almost one case. And in a situation with legal aid, you just have so many matters that people have to handle. And even here with attorneys who are working for pay, local attorneys, one, often lack the environmental law experience to bring these cases, or two, they have too many connections with the industry to be willing to bring these cases. And that's something I didn't speak about in detail, but the dependence of local attorneys in these small rural communities on the natural gas industry is very real.
Right. So there's no reason in principle why legal aid couldn't take on these cases. The reality, and this is important because people are saying always, oh, well, we just give more resources and so forth. But I mean, resources are limited, and in a sense, that sector of the legal profession has a practical dilemma. Mm-hmm. They basically cannot do environmental cases because it takes so much time and effort and energy, and they're going to lose anyway. So they do other kinds of cases, criminal cases, et cetera, which seem to be very deserving and don't take up, they're not a sponge. They don't take up all the resources. So it is a practical matter.
I would say so.
Not by any law or regulation that prevents environmental legal aid.
Correct. At least that's my understanding.
Yeah. It's interesting. I went to Hastings College of Law, but some years ago, but we never even heard of environment or environmental law. So where you're talking about lawyers who don't know anything about environmental law. Presumably a lot of those lawyers would have gone to, shall we say, the smaller or less well-known law schools. Is environmental law a big subject in the more wealthy or prestigious law schools? Would you?
I'm not sure if I would classify it that way. I think it's a niche area of law that has a growing interest. So you have some law schools that have actually developed up around that very topic. So I went to Vermont Law School that is known for that specific topic. Um, you know, sure, some of the Ivy League law schools are better known for it. But, you know, I think here in Ohio, you've got a great law school that's a state school, but it's just environmental law is not a big focus of their program. So I think it's more just because it's a niche area of the law and it's only now becoming more important to people.
But again, the curricula may reflect the industrial taxation issues in a particular state.
It absolutely does.
Vermont, it's not surprising to me that Vermont, does Bernie Sanders have anything to do with this? That Vermont has a law school that concentrates on environmental law, whereas Ohio does not.
Right. And I think Vermont also, you know, it has no fossil fuel resources. So they don't have that industry. Exactly. And yeah, I think that's the main point. One other point is law schools do have free legal clinics where they provide legal services. If you look at such clinics in West Virginia, for example, the funding for those clinics specifically states that they will not do certain types of work, including direct attacks on fossil fuel industry work, mining in particular. So,
state university law schools or state law schools?
Yeah.
Yeah. And they're restricted from, the legal aid clinics are restricted from taking these kinds of cases?
In those cases, it's not a legal aid. It is a clinic associated with the law school. So that, yes, has restrictions on it. And I know that University of Pittsburgh's law school also has similar restrictions on their law clinic.
This might also be something that we could explore this afternoon with judges and attorneys. So we do need to move on to the next presentation. Wow.
Thank you so much.
Thank you.
Thanks.